Green, attorney for the department.
All right, Richard Saldivar, attorney for the mother, Ms. Salinas. Ms. Salinas, will you announce, please?
Yes.
Please state your name.
Marisa Salinas.
Anna Swallow, attorney ad litem for the children ready.
Stacey Villa, CPS caseworker for the department.
Michelle Tavini, program coordinator with DePelchin.
Alexandra Vanderbilt, I am the investigation supervisor for the department.
Ms. Salinas, could you please announce?
Marisa Salinas.
Thank you. Anybody else that needs to announce? All right, thank you. Ms. Gavlik, do you have on a lanyard that's rubbing against the table?
Oh, it's my charm bracelet.
Okay.
They always complain about it. I'm going to put it in.
All right, thank you. Yeah, I keep hearing it, and it's thank you. I appreciate that. Okay.
Yes,
We're
sir.
here for a court-ordered services case, and my understanding is that you all were able to discuss it. Did you come to an agreement, Ms. Kyler Green?
We did come to an agreement, Your Honor.
All right, and what is that agreement?
So the agreement is for the court to order this case into TFF. What needs to happen, well, and what needs to happen first, not before the court orders this, but what needs to happen, kind of the correct order of events. This mother has been under a safety plan, Your Honor, since this case began, which was a couple months ago. And the parties are in agreement for, the mother should have taken a UA test for alcohol, I believe yesterday. And if the results of that come back negative, then the safety plan will be lifted. The mother has also requested to take, it's also requested that the court order for the mother to take a hair follicle test for alcohol so that we can have a baseline for that will help determine any future services that may or may not be different from the beginning of this case. Right now, the children are safe and their contact with the mother is appropriate. We just want to make sure that we have a full understanding of the issue, any issues we have with alcohol. And in regards to the services, Your Honor, I think that the specifics of that are going to be determined after the mom participates in an FSNA to determine what services are appropriate for her.
Is that your understanding of the agreement, Mr. Saldivar?
Yes, just at the hair follicle with the baseline to see how we're doing.
Okay, so I do have to announce, I was just informed from Ms. Marissa, she did not go in yesterday. She'll be planning on going in today.
Okay.
Well, and Your Honor, what that will do, if anything, so if there's any delay in getting the results from that, then that may impact whether or not the safety plan is lifted before or after the holidays, just given the fact that we're waiting on a facility to get us those results back. So that's the issue with that. I think that's why it was requested that she go yesterday. But if she has an issue getting this test done, it may be delayed because of the holidays.
Can I speak on that? I was just advised yesterday that I did have to go do that testing, but I did.
Hang on just a minute. We're in court, so when you want to speak, you need to let your attorney know, say, I need to talk to my attorney, so I can let you talk to your attorney before you say anything on the record, because you might say something on the record that is adversarial to your own case.
Okay.
We also have a procedure, and only attorneys are allowed to speak besides me, unless you're called as a witness or somebody, or I call on you. So do you need to speak with your attorney privately for a moment?
Sure.
Okay. Ms. Salinas, are you there?
Yes, sir, I'm here.
Okay, thank you. All right, Mr. Saldivar, were you able to address her concerns? Is there anything you want to add?
So no, so she just got notice that they're requesting a UA yesterday. Her son was sick. She had to take him to the doctor and to the hospital. So her and her son are sick. So she plans to go and get it done today. That's all. Just some confusion there, Judge.
Okay, but the agreement still stands. She understands everything. We're good to move forward. Okay.
We're good, Judge. She just wanted the court to notice that she wasn't ignoring it. It was just life happened and her son was sick, so couldn't get it done as soon as they text her. But we'll get it done today.
Okay, I understand. Okay, then Miss Gavlik, you're the investigator on this, correct?
Yes, Your Honor.
Okay. Do you believe that abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the physical health or safety? Okay, again, that was caused by an act or failure to act of the parent.
Yes, Your Honor.
All right, you believe the family preservation services are necessary to ensure the children's physical health and safety,
Yes, Your Honor.
excuse me. And you believe that the services that you all have agreed to, or the agreements that you all have made, is appropriate based on the safety risk assessment and the family assessment?
Yes, Your Honor.
Okay. You're asking the court to make this agreement an order of the court?
Yes, Your Honor.
Okay. Ms. Salinas, do you understand the agreement?
Yes, sir.
All right, and you understand what it requires of you?
Yes, sir.
Okay, you had the opportunity to address it with Mr. Saldivar?
Yes, we did.
Okay. And you're asking the court to approve your agreement today?
Yes.
Were you forced into this an agreement in any way, or was anybody offer you anything to get you to agree to it?
No, sir.
Okay. Anything that anyone else needs to add?
Judge, I would just request that Ms. Salinas be ordered not to alter or change, cut her hair in any way.
Anything else, Ms. Swallow?
Oh, no, Judge, that's all. Thank you.
All right, court finds, for the purposes of this hearing, that the mother has appeared and I believe signed a waiver of service as well yesterday, or on the 16th. Court finds that sufficient evidence exists to satisfy a person of ordinary prudence and caution that abuse or neglect has occurred, or there's a substantial risk of abuse or neglect or continuing danger to the children's physical health or safety caused by an act or failure to act of the parent. Family preservation services are necessary to ensure the child's physical health or safety. Family preservation services are appropriate based on the child's safety risk assessment, the child's family assessment, and court orders that the parties identify and require specific services narrowly tailored to address the factors that make the child a candidate for foster care. And court orders the parties to have the necessary staffings in this case. I think a family strength and needs assessment was also agreed upon, so to make sure that gets done. And then I'm going to order you not to alter your hair in any way when you go take that drug test, Ms. Salinas. That'll kind of invalidate the results. We won't be able to rely on that. You're not going to be in trouble with the court if it comes back positive. It just means that I know what kind of use we're looking at. That way we can figure out where we are and what we need to do in order to move forward. So the last thing you want to do is alter your hair, because it's just going to make things more difficult for you. Okay. Court finds that the agreement of the parties in the best interest of the children. If the mom does get a negative result, then safety plan will be lifted. Again, as Ms. Carla Green said, because we're not testing until today, could affect how this thing plays out for the holidays based on when we get results. So, but I will lift the safety plan as long as it's negative pursuant to the agreement of the parties. And then the hair follicle, obviously, as I've said, don't alter your hair. That will determine the services moving forward. Court finds that the placement of the children in the safety plan is appropriate, safe, and meeting their needs. And I'll order the family strength needs assessment to determine the appropriate services. We'll have our compliance hearing on February 6th, 2025 at 11:30. February 6th, 2025 at 11:30. Anything further, Ms. Kyler Green?
No, Your Honor. Thank you.
Okay, thank you all for your time and your service. And Ms. Salinas, good luck to you. Okay, I look forward to hearing good things in February.
Thank you, sir.
You're welcome. All parties are excused.
Thank you, Aaron.
Cher, are you there?
Yes, ma'am.
Can I bug you for a breakout room with my client?
Judge has to put y'all in there. I'm guessing he heard you ask, but I'll shoot him a message too. I don't have a way to do that.
Okay, sorry. Thank you.
You're the attorney ad litem, correct, Ms. Acevedo?
I have a mom, Judge.
Okay, then I think we've got it backwards in our system. Miss Greenlee shows that Mr. Brandon is the attorney for the mother.
That's what, that's what I show as well, Judge.
Okay.
I'll double check the order.
Yeah, let's check the appointments real quick. Have you had contact with Miss Allen, Miss Acevedo?
I haven't, Judge.
Okay.
And you know, I didn't look at the order. I looked at the email says that I represent her.
We'll get it figured out.
Rochelle represents the children. She's the ad litem for the children.
Yeah.
Then I'll put you, do you need a room with your client, Mr. Brandon?
No, Judge, I spoke with my client earlier today. I would like to talk to the department to see, I tried to get a hold of them, but they were in court. So I'd like to talk to them before we proceed, see if we've got an agreement.
All right, I'm putting all the attorneys into room 1.
Can you put the caseworker in as well, please, Your Honor?
Is it Miss Gavlik again?
Yes, sir. Your Honor, we're ready. Thank you.
CV, Department of Family Protective Services versus Kaylee Allen in the 38th Judicial District Court of Uvalde County, Texas. Court is streaming from Medina County via Zoom and YouTube. Are there any objections?
No objection.
No objection.
Ms. Kyler Green, would you please begin the announcements?
Yes, Your Honor. Good morning. Emily Kyler Green, attorney for the department.
Deidre Gavlik with Child Protective Investigations.
Alexandra Vanderbilt, Investigations Supervisor, Your Honor.
Desiree Flores, FBSS Supervisor.
Quincy Brandon, attorney for the mother. We're present and ready. Kaylee, could you announce for the record?
Kaylee Allen, mother.
Rochelle Acevedo, ad litem for the child, Judge.
Is there anybody else that hasn't announced yet?
Yes, Judge. Ashley Arena, Family-Based Safety Services caseworker.
All right, we are here today for TFF case. Parties were able to confer. Have you reached an agreement?
We have, Your Honor.
Yes, Your Honor.
And for the record, the court will take judicial notice that Ms. Allen was served by waiver on December 16th. All right, what are the terms and conditions of the agreement?
Your Honor, currently there's a safety plan that's put in place, and so the parties agree for that safety plan to remain intact. Currently, Kaylee and the child are residing with her grandfather, and that placement as of right now is safe and appropriate for both. The parties agree for this case to be under TFF, the parents as teachers model. The main services that the parties require right now is for Kaylee to receive drug testing and an OSAR, and then to the creation in the future of a family plan of service that will be narrowly tailored to address any other needs that she may have besides her issue with drugs.
Is that your understanding of the agreement, Mr. Brennan?
That is, Judge. When I discussed this case with my client earlier, my understanding from the pleadings where we were asking for a motion to participate strictly, I didn't realize it was a TFF. I told her that's what it appeared to be based on my reading of the affidavit. And she's in agreement either way, MTP or TFF. We went over that. But that's sounds like everything that we had discussed as possibilities with her. And unless she's changed her mind, I think we're good to go.
Ms. Allen, did you hear the agreement that Ms. Kyler Green announced?
That works for me.
You had the opportunity to discuss it with your attorney?
I did, yes.
All right, and you agree to participate?
I do.
And you're not being forced to agree to this? This is your voluntary agreement?
This is my voluntary agreement.
Okay. All right, then, Ms. Acevedo?
Yes, Judge, and I apologize. I got that mixed up. But I did speak with the caseworker. It sounds like that mom is very cooperative. And it sounds like I guess the FBSS team will be going out there on Thursday. So I'm hoping I can make that along with them so that I can see the child.
Okay. Very good. Thank you. Miss Orena, you're going to be giving testimony, correct?
No, Judge.
I'm sorry. Who would it be?
It'll be Deidre, Judge.
Where'd she go? I think we lost her. I think.
She's
Oh,
here,
there
I
she
see
is.
her.
Okay. All right, Miss Gabla, could you unmute for me, please?
Yes, sir.
Okay. You heard the agreement. Do you believe it's in the best interest of the child?
Yes, Your Honor.
And do you believe that it'll alleviate the effects of abuse and neglect that has occurred in this case?
Yes, Your Honor.
All right. And do you believe that it's necessary to protect the child's physical health and safety?
Yes, Your Honor.
And do you believe that the services that have been discussed here this morning are appropriate based on the safety risk assessment and the family assessment?
Yes, Your Honor.
Okay, thank you. All right, Ms. Collar Green, anything else?
No, Your Honor. Thank you.
Okay. Then the court will approve the agreement of the parties. Court finds that there's sufficient evidence, taking the affidavit into consideration as well, to satisfy a person of ordinary prudence and caution that abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the child's physical health or safety caused by an act or failure to act of the parent. Excuse me. Family preservation services are necessary to ensure the child's physical health or safety, and family preservation services are appropriate based on the child's safety risk assessment and the family assessment. Court will order that Miss Allen, if you get a hair test for any reason, don't alter your hair in any way. Don't color it or cut it or bleach it or shave it.
I colored my hair maybe a week or two ago.
Okay. Well, don't do anything before you test. Okay.
Okay.
So whatever you did a week or two ago, that's done, but don't do anything else before your test.
Okay.
Okay. All right. And the court will order the TFF parents as teachers model, the OSAR, and the drug testing, and then the creation of the family planner service.
I have a question.
All right. Before you ask your question, is this a question that you should be asking your attorney, or are you just asking about general information?
General information.
Okay, go ahead.
Is there like hours of the classes, or is it like days? How does that work?
Talk to your attorney and Ms. Gavlik about that. They'll provide you with those answers, okay?
Okay.
All right. Our next hearing is going to be February 6th, 2025 at 11 a.m. February 6th, 2025 at 11 a.m. In between now and then, you should be getting quite a bit done, Miss Allen, and I look forward to seeing what kind of progress you've made. This is the least intrusive way that you can get help for whatever services you need, whatever issues you're having. If you don't follow this plan, you don't participate, and you don't engage in it, then this gets worse and it gets more impactful on your life and more difficult for you and your child. I don't want to see that happen. I want to see you get involved in this, get the help you need, and then we get out of your life. Okay, that's the plan.
So does that mean until February 2nd?
6.
February 6th. Does that mean I'll continue to be on a safety plan until then?
That I don't know. We're just coming back to court. You can talk to Miss Gavlik and talk to your attorney, and we'll see what the safety plan needs are as y'all move along. You need to discuss that with your attorney. Okay.
Okay.
All right.
We'll discuss that in the future, Kaylee. Okay.
Okay.
Okay. Well, thank you all for your time and your service. If nothing further, all parties are excused, and that concludes the docket for today.
Thank you, Judge.
Thank you.
Judge.
Thank you.
Alexis Garcia for the department.
Samantha Winky, Family-Based Safety Services Worker.
Carol McKetta, Family-Based Supervisor. Anna Swallow, Attorney ad litem for the children.
Lucinda Mance, the attorney for the mother.
Crystal Flores Garza. Ms. Garza, if you can unmute and state that you are present.
Crystal Garza.
Richard Saldivar, attorney for Mr. Ayala, the father. He's present, Judge. He does speak Spanish, so I would be asking for a reset, Judge. I'm not ready. We had previously agreed to a pre-262 mediation, and I guess there was some back and forth on that, but I'm not ready, and I'm asking for a reset for those two reasons, Judge.
All right.
Goldie Rapson, Hill Country Casa, item.
There, Mr. Ayala, are you able to unmute?
Señor, ¿puedes decir tu nombre por la corte?
Alfredo Ayala.
Thank you.
Thank you, Mr. Saldivar. Okay, then the court will put it on the record that in the companion case, before I take testimony or anything or swear anybody, in the companion case, we had an order that the children in that case were where the other child, the child of this case is placed to, are going to be moved. I ordered that case to pre-262 mediation and reset it on the same day as the status hearing in this case. Well, the status hearing was going to be on the 22nd, but both of these cases are now set on January the 8th. This one at 1:30, the Kerr case at 2:30. So, Mr. Saldivar, you and your client are the only two new players involved, and based on your announcement, I don't think we really need to do anything else today. I'm just going to extend that order to this case as well. Order the parties to pre-262 mediation, ordering the child be moved with the other children, and then have the parties return on the 8th, depending on whether or not that case is settled. Obviously, we're dealing with the Kendall case and a Kerr case. It's the same parties, same mom, same children. There's only one extra dad out of Kendall. And I'm not sure what the facts and circumstances were right off the top of my head that required us to have the jurisdiction in two different counties. But one of the things I want the parties to discuss is if there's any issue transferring jurisdiction on the Kendall case to Kerr. I don't know if that's going to be, if there's a problem with that or not, but it makes sense to me that these cases would be one case and not two. But again, that would require a transfer, and I don't know which one would be which. I don't know where there's a mandatory transfer. I think a discretionary transfer is probably appropriate here, but I'm not looking at everything in front of me at the moment. So it's something I want the parties to discuss. With that being said, is there anything else that we need to take up today?
No, Judge, if the department could just meet with my client and get names of family members to assist with placement, that's all I would request from here until mediation.
Okay. Then I'll as in the other case, and everybody else knows this, Mr. Saldivar, but you don't. I think you might have heard this earlier, Ms. Garcia. I need everyone to sign the order resetting and extending jurisdiction, temporary management or temporary emergency jurisdiction, because I'm outside of my 7 days on that, but everybody's agreeing to mediation. So everybody should agree to the reset and the extension of the emergency order. So I'll need everybody's signature on it.
Yes, Your Honor.
All right.
Yes,
Thank
Your
you.
Honor.
Anything further we need to take up?
Judge, do we need an interpreter for mediation?
Yes, Judge.
Yes, I'll appoint an interpreter for a mediation and I'll approve those funds.
Thank you.
And then the same case, Miss Greenlee, from when we come back on the 8th for this case. We'll need to interpret that day too.
I've already started the email to the interpreters because we already have 3 set that day that need an interpreter.
That's right. Okay. All right, then if there's nothing further, thank you all for your time and your service. I'll see you on the 8th. Good luck in your mediation, and all parties are excused.
Thank you.
Department of Family and
Thank you,
Protective Services versus Destiny Hernandez and Elijah Martinez in the 38th Judicial District Court of Uvalde County, Texas. Court is streaming from Bandera County via Zoom and YouTube. Are there any objections?
No objection, Your Honor.
No objection.
All right, then with that, will you please begin the announcements, Ms. Kyler Green?
Yes, good afternoon. Emily Kyler Green, attorney for the department.
Kathleen Savage, attorney for the respondent mother, Destiny Hernandez. Destiny, if you could unmute and announce your name for the record.
Destiny Hernandez.
Irina Costa, attorney for the father, Elijah Martinez. Mr. Martinez, can you announce your name for the record, please?
Elijah Martinez.
Brittany Yalaguirre, child protective investigator.
Alexandra Vanderbilt, I'm the investigation supervisor.
Jennifer Harris, attorney and guardian ad litem for the child.
Vala Rodriguez, family-based safety services worker.
All right, we are here for a progress hearing. Or yes, a compliance hearing, excuse me, on a TFF case. And we were last.
Your Honor, I don't believe it's a compliance hearing.
No.
No,
It's
we
not
had to reset because the parents were minors and we had service.
Right, that's right.
And we were going to have guardians appointed for them.
It was my mistake to label it that way on the docket, Judge.
Okay. So where do we stand right now as far as the representation of the parents?
They have attorneys. I was never made aware of whether or not guardians were appointed for them. And I didn't see any appointment orders for guardians come through on my end.
Miss Greenlee, do you have any information on that?
I was just sending you a message. None were ever sent to me.
Okay. Who was, I don't know who would have been on the hook for that.
Probably the department, Your Honor, but I obviously we did not do that.
Okay. How old are both the parents still minors right now?
Yes, Your Honor. They're next to friends were served, but we don't have their guardians here.
Okay. So then we just need to reset to have them present. So they were served, appointed and served, but they weren't notified. Is that what you're telling me?
No. Our client's parents as next to friend were served. So the parents are in front of us.
All right. Well, we need to get that done. I don't know that I can move forward today without that being in place because they can't consent to anything and they can't, without the guardian here, I just think my hands are tied. I don't know, does anybody have any law or any authority to tell me otherwise? No? Okay. Well, then we're going to have to reset this. I can't see anything in front of me as far as the notes that I might have made the last time we met. Didn't we talk about this? Wasn't this on the record?
I believe so. We also met in a breakout room, Your Honor.
Yeah, and there's nothing in my case log that shows me there should be notes there and they're not there. But this system has been kind of funny today, so I don't know. All right.
No, and
go ahead.
I think Your Honor, just the big thing I think from the department's perspective that I was tracking was service to the to the guardians of the parents, but I don't even think anything was drafted to appoint guardians for them. So that was just, I think, a complete oversight on my part.
And Your Honor, I don't know if this is a memory jog or not, but we discussed either having one guardian for both parents or two guardians.
Yeah, I remember that, and we needed two. Okay. Yeah, thank you, Mr. Costa. I do remember that. Well, we need to get that done. We need to get them served, and then we can have a hearing. And again, I want to make sure I say this correctly. I'm not appointing them guardians in the sense of guardianship. This is guardians for service and for basically a second attorney on the case pursuant to the family code. I want to make sure that's clear. And there's a statute in there that addresses it when it comes to service. Okay, anything else that we need to take up today? We just need to get a reset date. I don't know how long it's going to take. Probably at least a couple weeks, huh?
And I can reach out to the court and let you know when we get it done.
Okay. Then just, if you would, Miss Kyler Green, just stay in touch with Miss Greenlee on this. And then Miss Greenlee, you can docket it once you get a little bit more information. Let's not, our next compliance date isn't going to be until March. So obviously we're going to have something this month. Because this case we've got to hear it. So I would think it's probably going to be sometime in the next 2 weeks, but we have a Uvalde docket next Thursday, but I don't think we're going to make it in time. Maybe
that'll be our goal.
Okay. Well then, that docket's, never mind. That docket's not going to work because we've got a 3-hour hearing that day.
Yeah. I could set it on the Gillespie day at 11 o'clock.
Okay. That would be the following Thursday, right?
Correct.
So the 23rd?
Yes.
Okay.
11 o'clock.
I think you just said that and I completely glossed over. All right.
Okay.
All right. So we're going to reset to January 23rd at 11 a.m. Anything else? I mean, I can't really do anything else today. Just y'all keep doing what you're doing on your end, Miss Agidi, and then we'll get it figured out when we come back on the 23rd. Okay. Thank you all for your time and your service. If nothing further, all parties are excused. And with that, Ms. Kyler Green, will you begin the announcements?
Yes, good morning. Emily Kyler Green, attorney for the department.
Brittany Liala Aguirre, child protective investigator.
Vale Rodriguez, family-based safety services worker.
Kathleen Savage, the attorney for the respondent mother, Destiny Hernandez. She's present, Your Honor, and we are ready. Ms. Hernandez, if you will unmute yourself and announce your name for the record.
Destiny Hernandez.
Deborah Fuller, guardian ad litem for Destiny Hernandez, Your Honor. Ready?
Irene Acosta, attorney appointed to represent the respondent father, Elijah Martinez. I'm ready. Mr. Martinez, can you please announce your name?
Elijah Martinez.
Quincy Brandon, I've been appointed as a guardian ad litem for Elijah.
Jennifer Harris, attorney ad litem for the child.
I mean, I feel the same way.
Colleen Coleman, family-based safety services supervisor.
Bridget Gonzalez, CPI supervisor covering for Alexandra Vanderbilt.
Anyone else that hasn't announced? Thank you. We're here today on a court-ordered services case. We've had prior proceedings, but we had to reset to come back because the parents in this case are minors and we needed to have guardians appointed, which We have our guardians ad litem appointed. They are present. Ms. Fuller and Mr. Brennan are present. Do you all have an agreement or do we need a contested hearing?
Your Honor, I believe that there's an agreement here. There's already been a family group conference and family plans of service have been created and the parents are already engaging in those services.
Okay. Anybody have any other understanding?
No, after speaking with Ms. Hernandez, she did indicate that she was in agreement to do services. I just need to know which services that they're asking her to do.
Same
for my
for, okay, all right. Ms. Acosta, Ms. Savage, you're in the same frame of mind.
Yes, Your Honor, and I believe
Yes.
it was TFF and random drug testing. I recall we had worked out an agreement quite a while ago. It's just taken a while to get everything situated.
Do you know if it was the PAT program or was it something else?
It's
should
the
be
PAT
the-
program.
I'm sorry?
The PAT program, Your Honor, the parents
Okay.
as teachers.
All right.
Your Honor, sorry, Your Honor. On the family plan of service, it was reviewed with the parents that they are to participate in the PAT program. They're also to go to South Texas Rural Health for drug and alcohol assessment and any services needed, along with the random drug testing.
And Your Honor, I would just ask that any results from any testing are be forwarded to my
Hang on
office.
just a second. Go ahead, Ms. Fuller.
I would just ask that any results from any testing, any notes from the PAT program be forwarded to my office so I can review them prior to the next hearing.
All right. Ms. Kyler Green, do you have anything else?
No, Your Honor. As I said before, I think the parents are already participating. They've already begun drug testing, and there's also a safety plan that's been in place that the parents have been following as well.
Okay. Mr. Rodriguez, are you the actual witness if this case were to be contested?
Yes, Your Honor.
Okay. You believe that this agreement and these services are in the best interest of the child?
I do, Your Honor.
All right. And you believe that it's necessary for the court to monitor these services?
Yes, Your Honor.
And to address the concerns?
Yes, Your Honor.
Okay. Anybody have any other questions for Mr. Rodriguez?
No, Your Honor, I did have one agreement we failed to mention in regards to that safety plan. When this case was originally set, it was a 24/7 safety plan where the parents had to be continuously monitored. However, we are requesting that that specific provision be lifted, given the parents have been communicating and have been participating. However, the mother would agree to remain in the home with the child of the mother-in-law where that safety plan is in place. We are just asking that the requirement that all interaction with the child not have to be supervised 24/7.
Is there any objection to that?
No, Your Honor.
Ms. Kyler Green, the department's okay? Okay. All right, Ms. Harris, is there anything you want to add?
Your Honor, I'm glad we were finally able to do this. I feel like we can get moving now.
Good. All right. And my understanding is that the parents, in addition to being minors, are also indigent and unable to afford counsel, excuse me. I'm going to ask them just on the record briefly. Ms. Hernandez and Mr. Martinez, can you unmute, please? Are either one of you able to afford an attorney to represent you in this case?
No.
No, sir.
Okay. All right. Do either one of you receive any type of governmental assistance?
No.
Right. Are either one of you employed?
Yes, yes, sir, I'm employed.
Okay. After you get done paying all your bills for the month, do you have any money left over to pay for an attorney?
No. No, sir.
Okay. I'll maintain agency findings for the parents and maintain the appointments of their attorneys ad litem and their guardians ad litem. I'll make a finding that I'm looking for the right language here. All right. Court finds sufficient evidence to satisfy a person of ordinary prudence and caution that the family, or that abuse or neglect occurred, or there's a substantial risk of abuse or neglect or continuing danger to the child's health or physical safety caused by an act or failure to act of the parent. Family preservation services are necessary to ensure the child's physical health and safety. Family preservation services are appropriate based on the child's safety risk assessment and the child's family assessment. And I'm ordering the parties, and it sounds like you already have, to make sure that the services are narrowly tailored to address the factors that make the child a candidate for foster care. And these services, as stated on the record, are ordered. Our next hearing is going to be a compliance hearing, and that's going to be March the 6th, 2025 at 11 a.m. March 6th, 2025 at 11 a.m. I'm going to order that the notes that Ms. Fuller requested be provided to the parties as appropriate. And Ms. Hernandez and Mr. Martinez, I need you to understand that these services that are being offered to you and this court order is the least restrictive way to get help for families through state intervention that there is. If you don't follow these orders, or it sounds like you already are, but if you don't, then things get more difficult, things get more complicated, and then it gets to a point where your child can be removed from you. And I don't want to see that happen. I'm going to grant Ms. Savage's request that the requirement for 24-hour supervision be lifted. But I need you both to understand that you've got to work really hard and do exactly what has been ordered today. Maintain your contact with Mr. Rodriguez. Okay. Sometimes these cases, thank you. Sometimes these cases only last a couple months, and then we get out of them, and then we're done, and you never have to see anybody again. But sometimes parents, they don't do what they're ordered to do, and then these cases wind up taking a lot longer, and then sometimes they get worse. Okay.
Yes, sir.
I don't want to see that happen to either one of you. I want to see you get your stuff figured out and spend your time with your child and move on down the road. Okay.
Yes, sir.
All right. Well, good luck to you. And I'm glad to hear that you're already participating in some things. Ms. Kyler Green, is there anything else that I need to address?
No, Your Honor. Thank you.
Okay. Well, thank you all for your time and your service. And if nothing further, all parties are excused. Have a great afternoon.
Thank you.
Okay, thank you,
From
sir.
Medina County, Texas. Are there any objections?
No.
No, Your Honor.
All right. We've got a lot of people here, so I need the attorneys to announce. And if you have your client here, please ask your client to announce. And if you have witnesses here, please ask your witnesses to announce by name. And then let's just start with the department and then go through Mr. Rudkin and then Miss Perry and then down to the ad litem.
Jessica Thompson for the department.
Kurt Rudkin. And for the mother and announcing not ready, my client's not been served. I have not had a chance to review the voluminous pleadings that have been recently filed, and I believe there's been a request for an in-person hearing.
Randy Dean present.
Perry, attorney for Chris Gilliam. You want to introduce yourself?
Chris Gilliam, present.
And
Randy Carmish, present.
I have another one. Mario present. Also, Judge, I have Miss Peterman. She's a witness today.
Ashley Peterman, Department of Family Protective Services.
Thank you. And Judge, we were trying to be prepared to be ready today, but since one party has not been served, And I would really prefer to have an in-court hearing because there's so many witnesses.
Well, I would too. If we've got that many witnesses, I would prefer it to be in person as well.
Kathleen Savage, attorney ad litem for the child. Your Honor, I'm ready. There's also Justin Bragg, who I plan on calling as a witness, in addition to Lacey White, who are also present, Your Honor.
Officer Frederick Salazar with the Kerrville Police Department as a witness.
Goldie Rabson, Hill Country Casa, unit item for the child.
Is there anybody else that has not announced?
Helen Krause, investigation supervisor for the department.
Sherry Arnold, CPI investigator for the department.
Esther Coleman with Family and Protective Services.
Anybody else? All right, since we have everybody here, and I know you're asking for an in-person hearing, anybody who's here on subpoena is going to be held over to the date we come back. And I'm trying to pull up my calendar right now.
And Judge, do they have to be sworn in to do that, or?
No.
No? Okay.
No. I mean, we could, theoretically, we could begin this hearing right now and call one witness, ask a few questions, and then I can, instead of resetting it, we can recess it. And then everybody will be held over and everybody who's here will have been sworn and we can move forward. Is there any objection to me doing that?
No, not for me.
And I'll put you're not ready on the record. I do know that your client is here. Would ask if she would be willing to enter an appearance.
Sure.
And then I'll, if that's the case, then I'll relieve the department of the burden to get her personally served. Find that she's appeared today. And Miss Greenlee has given me the 24th of January, which is a Friday.
That works for me, Your Honor.
That's fine.
All right.
Just a moment, I'm still trying to find it, Judge. January the 24th, correct?
Yes.
That's good for me.
All right. Miss Greenlee is going to check with the DJ's office in Kerr and make sure that we have a courtroom that day. I understand that you're asking for a full day.
Well, it may take that, Judge.
Your Honor, we already have multiple officers, body cam footage, parents' testimony, a couple witnesses. I think it would probably take a good 6 to 8 hours.
And
would that be at 9?
Well, my question is this, is it warranted? I want to make sure if it's warranted, then we'll do it. Is it warranted for all of this evidence to come in, or is there something that the parties can stipulate to? Is there anything that you can stipulate to?
Not me.
All right, well, if I give it a full day, probably not going to go over a full day. It's very unlikely that if we spend 6 to 8 hours on this adversary hearing, which is essentially a temporary orders hearing, that I'm going to extend it over into another day. So Be prepared to finalize within 6 to 8 hours. Use your time wisely, pick your witnesses and your testimony wisely.
Your Honor, I would ask if we're appearing in front of the court and putting on all this testimony, the parties agree to waive de novo?
From the order today?
From
No.
whatever order is rendered on the 24th.
No.
Well, then should we just ask for a setting with the district court judge?
Well,
That's fine with me because he knows the history in this case and what's going on. I was going to ask this to be consolidated in with our case. We've got a pending case, Judge, with Judge McGuire. We had new temporary orders rendered in October, which were finally signed yesterday. And it might warrant just going to the district court judge.
I do think he needs to hear the information of the abuse and neglect because I don't think that's been adequately testified to him.
okay. This is what we need to do then. I'm not going to start the hearing. I'm going to enter the order where I'm resetting this to January the 24th at 9 a.m. in Kerr County. And I'm going to hold over any subpoenas, any witnesses that were asked to be here, move it to January 24th at 9:30 in person in Kerr County. And in the meantime, I need the parties to contact Christine with Judge McGuire's office and inform him that this case is before me, and find out if he wants to take it back because it's been referred to me from the 198th. If he's got a civil case already and the facts and the circumstances are the same, and whatever decision I make is going to probably be de novo on either side, then it makes most sense from a judicial economy perspective for him to hear it. But that's the decision that I want him to be part of that decision. I don't want to make that decision for him. He and I need to discuss it. You all need to bring it to his attention and bring it to Ms. McIntyre's attention and make sure that they've got room on the docket to accommodate it, because it's a timeliness factor too.
On January the 24th or at another date that's not too far out?
You all need to, whoever's driving this train needs to contact Ms. McIntyre today.
Okay.
And let her know what's going on. Give her a rundown of what's going on, and then find out if and when Judge McGuire can hear it.
Okay.
And then if he takes it back, if he takes back the case that he has referred to me, and he'll hear it in person for you in a timely manner, then I'll drop it off my docket on the 24th. But I'm going to keep it there until I know what the answer is.
Okay. I'll be happy to contact him, but I don't know if you want Jessica Thompson to do it or.
Well, you're the one requesting the in-person hearing.
I'll call him.
And you have, my understanding is that you have a civil case with him already, correct?
I do.
So to me, it makes more sense for you to contact Christine. But if you want to be on a conference call with Ms. Thompson involved and Ms. Savage and Mr. Rudkin involved, I think that would be fine too.
Okay.
I think you're in a unique position to call her and talk to her about this case because you've already got something on his docket regarding the same children.
That is correct, Judge. Thank you.
Well, whatever happens, make sure you talk to all parties about it. And if I'm going to call Judge McGuire myself and make sure he understands the situation. And if I get an answer, I would like for him to hear from you all as well. And I'm going to tell him that I think he needs to communicate with the attorneys, or at least whatever you tell Ms. McIntyre. And then if after those two conversations, he feels as if I should hang on to the case, then I'm going to hang on to it.
Thank you.
Okay. Anything further? I really can't take anything else up today if we're going to do it this way. But
one last thing, Judge. this child has been removed from father, and it's been since December the 23rd. He has not had the opportunity to even see her. They tried to schedule something at CPS, and we're fine with supervised at CPS, but for some reason, and this goes in the background, so I can't say too much because that's not right, but Miss Savage says that her client, the little girl, does not want to see dad. I believe that she's being coached to say that, but is there a way that we can go ahead and get that scheduled so dad and little girl can see her father? I think it's in her best interest.
Your Honor, rebuttal.
Yes, please.
I have visited with my client privately, and she has expressed not wanting to see her father. This child's been a victim of abuse and neglect at the hands of her father for a very significant period of time. The court is aware I have filed aggravated circumstances against this father, and I am requesting a no contact order on behalf of my client. So I would be adamantly opposed to any kind of visitations. This child needs to get in therapy. Frankly, I think we need to have a recommendation from the child's therapist before any contact between the father and the child resumes.
Okay. I'm going to try to get a hold of Judge McGuire now so I can try to get an answer. And I'm going to take that under advisement for the next few minutes, and I'll come back and I'm going to let you know if I was able to get a hold of him and make a ruling on that. So we'll be in recess for a few minutes. Please hang tight.
Thank you, Judge.
I was able to speak with Judge McGuire and explain to him the situation, and he is going to take the case back on his docket. So the entire case is going to be referred back to the 198th. It will be removed from my docket, and Judge McGuire will hear both the civil and the CPS. So the hearing for the 24th is not going to happen. We're taking that off our docket. It's possible that Judge McGuire may choose that day. I don't know, but my order stands to the attorneys to contact Ms. McIntyre today and let her know that I spoke with Judge McGuire. Judge McGuire is taking the case back, and you need a setting, and that we had a setting on the 24th, and that if y'all want to use that setting and he's available, then that would work out great because everybody's already aware of it, but they may not have that available. So you need to talk to Christine about it. That'll be all. I can't make any further orders on the visitation because I'd have to hear evidence, and Judge McGuire, who's the referring judge, has said he's taking the case back. So I can't hear anything. You'll have to go in front of him for that relief.
Thank you.
All right. Thank you.